It took a year to press charges. Don't I have the right to a speedy trial? Find out in this month's Myth of the Month. So many people confuse the right to a speedy trial with the statute of limitations. While many people think they know what the right to a speedy trial is, most people, at least when it comes to criminal law, aren't very familiar with the statute of limitations. Now, the statute of limitations is the time limit that the prosecutor or the officer has to file a certain type of charge. So for misdemeanors, the prosecutor typically has up to 1 year to file misdemeanor charges. And for felony cases, the prosecutor typically has up to 7 years. Now, that might change depending on the type of charge and circumstances, but that is totally separate from the right to a speedy trial. In other words, if it takes a year or almost a year to press charges on a misdemeanor, that doesn't necessarily mean that they violated your right to a speedy trial, because that is entirely separate from your right to a speedy trial. Now, that could cause some potential other issues when it takes so long to file charges, which is why it is important not to wait that long and to contact an attorney immediately if you're suspected of a crime. I offer free consultations, so I highly recommend, if you believe you may be under investigation for a criminal offense, contact a lawyer immediately. My number is 480-927-3700.